Good evening and welcome to the discussion on arbitration and FDI being organized as a part of the India Law Forum and LITFest under the track on law and ease of doing business under the aegis of the 82nd SKOCH Summit being held by SKOCH Group this year, 2022. India's decision to not sign the RCEP was predicated on MFN forward obligations and ratchet clauses that many, including SKOCH Group, vehemently believed would serve as a backdoor for China's entry into Indian markets. Subsequently, the Standing Committee of External Affairs, chaired by Mr. P.P. Chaudhary, submitted a report on the subject, India and Bilateral Investment Treaties, on the 10th of September 2021. The committee noted that up until 2015, India had signed BITs with 83 countries, of which 74 were in force. India revised its model BIT text in 2015, and the committee observed that since then, India has signed new BITs with only 4 countries and is negotiating with 37 countries and blocs. It also noted that India has terminated its older BITs with 77 countries. The committee observed that the number of BITs signed by India after 2015 and the number under negotiation are inadequate. It noted that BITs have the potential to attract foreign direct investment by providing prospective investors with a higher degree of confidence in their investments. In this light, the committee recommended signing new BITs with countries with which India has had such treaties in the past and signing BITs selectively in identified priority sectors, as well as the early completion of treaty negotiations. Interestingly, the committee also noted that so far there have been 37 notices of dispute or letters intending to raise a dispute against India under various BITs. Our panel of experts this evening discusses all this and more. Our first speaker in the conference on arbitration and FDI is Professor Bimal Patel, Member Designate, International Law Commission and Vice-Chancellor of the Rashtriya Raksha University. Professor Dr. Bimal N. Patel is currently the Vice-Chancellor of the Rashtriya Raksha First Police and Internal Security University of India and a member of the National Security Advisory Board of India. Professor Patel has also recently been elected as a member of the UN International Law Commission. Professor Patel is a former international civil servant, scholar, and academician of international law and diplomacy. As an international jurist, Professor Patel has extensively studied, researched, and commented on published works on the administrative, procedural, and substantive jurisprudence of the International Court of Justice and various other international forums. Professor Patel has also been instrumental in drafting several legislations in India and holds numerous global academic appointments. Professor Makane, Moïse, Mbengue, Professor International Law Faculty of the Faculty of Law at the University of Geneva, also serves as the director of the Department of International Law and the International Organization. He is also an affiliate professor at Sciences Po Paris. Since 2017, he is the president of the African Society of International Law. He was the lead expert for the negotiations and drafting of the Pan-African Investment Code in the context of the African Union. He has acted and acts as an expert for the African Union, the Secretary General of the United Nations, the UNEP, the WHO, the World Bank, the ILO, and the Organization of the Islamic Conference, as well as the International Institute for Sustainable Development, against others. He also acts as counsel in disputes before international courts and tribunals, in particular before the International Court of Justice and in investment cases, and serves as an advisor for governments. He is involved in the negotiations of several international investment agreements in Africa. Mr. Vyapak Desai, head International Disputes Resolutions at Nishith Desai Associates, also heads the investigation practice at this multi-skill research and strategy-driven law firm, Nishith Desai Associates. He's a senior attorney with the firm. Mr. Vyapak Desai specializes in bringing in the highest level of analytical and innovative input in cross-border complex, contentious matters and corporate regulatory investigations. He has also led the corporate and securities practice at the firm in the past. We're delighted to have Ms. Naomi Briercliffe, Counsel, Allen and Overy, United Kingdom, with us. Ms. Naomi Briercliffe represents clients in international and commercial investor state arbitrations and has also advised on state-to-state disputes, including those before the International Court of Justice and the Iran-US Claims Tribunal. She has experience of institutional and ad hoc arbitration proceedings, including arbitrations under the ICC, the LCIA, the SCC, the ICSID, and UN CITRAL rules. She has appeared as counsel and advocate in commercial, investor, state, and state-to-state cases. Mr. Manish Sansi is Chief Legal Officer at Vodafone-Idea Limited. He was previously DGM, Legal Secretarial at Indus Towers Limited and Vice President, Legal and Secretarial at Telenor. He has also served as the General Counsel for India and Company Secretary, as well as Deputy Chief Compliance Officer for Tata Communications. He's an experienced in-house legal professional with more than 25 years of experience with leadership roles in legal functions. Our moderator for today is Anirudh Lekhi, an international dispute resolution attorney. Anirudh is an India qualified lawyer with an interest in international commercial arbitration, international investment arbitration, and public international law. Prior to joining the MIDS, Anirudh worked at Shardul Amarchand Mangaldas, New Delhi, where he was an integral part of its international arbitration and litigation team for upwards of 3 years. At Amarchand, he represented clients in international arbitrations under various institutional rules, post-award actions, and also worked on complex shareholder disputes, regulatory actions, and post-merger litigations. Additionally, Anirudh holds an LLM from Columbia Law School, where he graduated with academic distinction as a Harlan Fiske Stone Scholar and obtained the Parker School Certificate for Proficiency in Foreign and Comparative Law. He's also served as the editor of the American Review of the International Arbitration and was a research assistant to Professor George Berman at Columbia. Over to you, Anirudh.
Thank you so much for the introduction, Rohan, and thank you to the very distinguished panel that is joining us here today from various different parts of the world and various different time zones. A very warm welcome to all our viewers who are here to listen to these extremely illustrious individuals. To give a context to the current debate and the current discussion, India is pegged to receive as much as $100 billion in foreign direct investment in 2022 alone. And it is likely to become a $5 trillion economy in the next 5 years. Therefore, with the ever-increasing FDI, it is also poised to become a hotbed of international dispute resolution, in particular international arbitration. Therefore, and in this regard, a responsible and efficient legal machinery that offers a forum to an investor to ventilate its concerns is considered extremely imperative. And one way of conferring these investment protections is, as we all know, through bilateral investment treaties, which offer a very novel method of dispute resolution that is directly between an investor and the state. However, and of late, the ISDS setup has come under scrutiny with its potentially crippling awards that may have, drastic consequences on different economies. And this, to a large extent, has been attributed to vague and undefined standards that may have been found inside these bilateral investment treaties. Today's panel has assembled to address the merits and demerits of this system and explore its linkages with foreign direct investment. And therefore, the first part of today's discussion will open the floor to our panelists who will make certain preliminary remarks on today's subject of discussion. We will then proceed to explore the architecture of these bilateral investment treaties and the potential ways in which their phraseology can affect foreign direct investment. And finally, this panel will discuss the current trends in ISDS and their impact on investor confidence. But without any further ado, I would direct my first question to Professor Makane. Professor, for a very long time, many of the capital exporting states have been advocates of maintaining the current ISDS system. And you have, in fact, been a very vocal critic of the so-called global north that understands the drastic consequences of ISDS and sells the promise of greater investment through these bilateral investment treaties. So do you find any merit in the argument that greater FDI will come after signing bilateral investment treaties? And further, given that there is certain information asymmetry before a state goes on to sign these bilateral investment treaties, how have you responded in the course of your negotiations with respect to various governments?
Thank you so much, Anirudh, and thank you again very much to the organizers for the invitation. It's a great pleasure to be on this panel with such distinguished colleagues and experts. And of course, I would like to congratulate again Professor Bimal Patel for his election at the International Law Commission. Anirudh, if I can just go straight to the point with respect to your main question regarding whether bilateral investment treaties can really increase investment flows on the territory of a state. Let me just say straight away that no, there is no evidence that concluding bilateral investment treaties would actually contribute or would actually increase investment flows on the territory of a country. I've been working for many countries in Africa reviewing their bilateral investment treaties policies, and it's very surprising to see that in many countries, when you check who are the countries from which most of the investors would come from, you would see that quite often the host country at stake doesn't have any BIT, any concluded bilateral investment treaty with the country or the countries from which most of the investors are coming from. And I could give many examples. What would attract FDI on the territory of a state is a favorable investment climate. Investors, they go where they know that there would be a favorable investment climate. And bilateral investment treaties, they have not focused on building a favorable investment climate. If you look at the traditional model of BITS, the focus has been only on investment protection. So what is very important when it comes to FDI is actually investment promotion and investment facilitation. This is how you build a favorable investment climate in a country, by promoting investment, and particular investment facilitation is very fundamental. And if you look at the traditional architecture or design of BITS, what you will see is that promotion is not there, facilitation is not there. Yes, many of those bilateral investment treaties would be entitled agreements on the promotion and protection of investment between two nations, but the idea of promotion stays or is just limited in the title of the agreement. No mechanisms, no devices are truly put in place to actually ensure that the bilateral investment treaty would be a tool for investment promotion. No mechanisms, no devices are put in place to ensure that the BIT would be also an instrument of investment facilitation. So this is what we really need. If we really want bilateral investment treaties to attract FDI, to be real instruments for investment attraction, then you need to make sure that mechanisms, provisions, devices are incorporated in relation to investment promotion and investment facilitation. And this is why, if you look at the most recent generation of investment agreements, they do no longer focus, at least exclusively, on investment protection. In Africa, we are right now negotiating a future investment protocol to the African Continental Free Trade Area. And the focus is on investment promotion and investment facilitation. So it doesn't mean that there won't be any protection, but you have several provisions insisting on investment promotion and on investment facilitation. If you take the Brazilian model, Brazil has always isolated itself from the traditional dominant model of BITS. And what Brazil has come up with is an alternative that is actually focusing on investment facilitation and investment cooperation. Investment cooperation is also fundamental. It's one aspect of investment promotion. Investment cooperation is also fundamental for really attracting FDI on the territory of the state. The traditional model of BITS, they don't lead to any cooperation. The day India has concluded a bilateral investment treaty with a third state, it's the last time that India hears about that BIT. There's no cooperation at all that would actually put in place a process that would allow the two countries to cooperate and to foster FDI flows on their territories. So this is another vacuum, another element that is absent from BITS, this aspect of cooperation. And one other aspect that has made BITS quite insufficient or quite, I would say, useless in attracting FDI is that bilateral investment treaties, they do not take into account what we call the investment life cycle. You know, the investment life cycle is based on 5 main phases. You would have what we call a vision or a strategy for FDI. That's the first element of the investment life cycle. Then the second element would be a policy of attraction of FDI. That's the second element of the second phase or second element of the investment life cycle. Then the third element of the investment life cycle would be, you know, policies for establishment, policies, regulation for the establishment of FDI on a territory. And the fourth aspect of investment life cycle is investment protection. So standards that would allow to protect. BITS, they've been only focusing on that fourth aspect of the investment life cycle, which is protection. But you have a fifth very important aspect of the investment life cycle, which is investment retention and expansion. Investment retention and expansion. So meaning, once the investment is on your territory, how do you make sure that you retain it? And how do you make sure that it would expand? Attracting investment without retaining it, without ensuring expansion is useless. And BITS, the problem with BITS is that they kind of nullify investment retention and expansion, you know, because of what? Because of ISDS. Because of ISDS. You were asking me what is, in my view, the main problem, the main drawback with ISDS. The main problem is that ISDS is not focusing on dispute prevention. ISDS is very confrontational, in particular, the investment arbitration, the investor-state arbitration aspect of ISDS is very confrontational. It puts the investor and the host state always in a confrontational relation. But if you want really to retain investment, to expand investment, you need to think about investment dispute prevention. Make sure that when investors have difficulties on the territory of a state, that they would have access to grievance mechanisms, that they would have access to alert mechanisms, that they would have access to aftercare mechanisms that would actually allow them to alleviate, to de-escalate their dispute with the host states. And this is how you build a win-win relationship. So ISDS itself, which is the core element, the core provision of BITS, is not the right tool for investment retention and expansion because it is confrontational. Once you have a dispute between an investor and a state, it destroys the investment relationship because an investor that pursues a state, that sues a state and asking that state to pay $1 billion, I don't know how many $billion, will of course not stay in that country. And this is also very damageable to the reputation, to the image of the country that is being sued. So this mechanism, which is ISDS, which is at the heart of BIT itself, is counterproductive to really ensure, you know, FDI attraction and FDI retention and expansion in developing countries.
Thank you so much for those very, very candid remarks, Professor Makane. And I'm sure you will find many allies in India who will echo those remarks. And I am just reminded of a statement that was made by one of the Brazilian investment negotiators during the course of my preparation for this summit. And I thought in light of your remarks, it'll be very interesting to quote his remarks in the backdrop of what you said. And our Brazilian negotiator said, and I quote, investment treaties are much like prenuptial agreements where a couple agrees to get married, but is already looking ahead to the terms on which a divorce might happen. After that divorce, each party goes its separate way and is not to be seen again. I prefer to think that Brazil's investment facilitation approach as more akin to a couple's counseling, because we are trying to facilitate a long-term relationship that remains positive rather than envisages a future divorce. It's a completely different approach, unquote. And therefore, this is one view that is now gaining a very wide groundswell across the world, especially India. And in that light, I thought it will only be appropriate to get another very, very distinguished scholar from India to weigh in on this issue, Professor Bimal Patel. Firstly, many, many congratulations on your election to the ILC, and it was a very proud moment for all of us Indians for you to win in such a resounding fashion. My question to you is that the job of the ILC is primarily to codify customary international law. And the articles on state responsibility have provided a very good scaffolding for a lot of jurisprudence around investor-state dispute resolution. In this regard, how do you view the role of international law in creating an environment that facilitates investment and trade?
Thank you very much, Anirudh. First of all, thank you for the invitation, and thank you, Professor Makane, for your congratulatory remarks. We are meeting after 10 years since we met in GNLU. Due to short notice and hectic agenda, my remarks are perhaps inchoate, and my apology for the same. But I will be focusing on what the law and obligation regime is instead of what it ought to be. So the risks associated with the continuous wave of pandemic, the pace of development, deployment of immunization programs, economic support measures, the continuous fragility of macroeconomic situations in key emerging markets, the deferred situations arising in few developing countries, including Sri Lanka, and the uncertainty or the global policy environment for investment will all continue to affect FDI flows. Therefore, one has to creatively and innovatively think of the role of international law and international obligations, because such situation has arisen more than after a century. In 20th century, there was no global international law. It was international law meant for few Western and Latin American countries. Africa, Asia, and Pacific Island states were yet to be decolonized and to become part of international economic landscapes. The pandemic health crisis has helped to increase the use of screening mechanisms to oppose, sometimes publicly, transactions involving the sale of companies considered to be strategic. If you see, the new political and economic nationalism has emerged, which is contradictory to global commons needs. Old international law prior to pandemic will be unable to take care. Therefore, a lot of rules and norms for international obligations have to be rewritten or practiced afresh. We all welcome FDI for employment, but also for its positive spillover effects on political, diplomatic, and commercial relations. However, the new economic nationalism will give stiff resistance to FDI. One will see, in my view, a lot of short-term bargaining at bilateral multilateral level to fix short-term solutions. In other words, short-termism of international obligation will arise. As far as India is concerned, one can expect bright short to mid-term future. As technology and health sector will see strong boom, there will be rush for FDI to India in these two sectors, because India enjoys age and therefore India will see significant transaction activity. And in these sectors, and more mergers and acquisitions are likely to occur. However, as the current international law was unprepared for such eventuality, India or countries in similar situation will rely on bilateral mechanisms instead of international treaty framework. On a flip side, India has to be careful because there will be a lot of predatory takeovers which will be skillfully enforced and orchestrated by countries supporting predatory takeovers. On a positive side, new sectors focused upon by India strongly, such as infrastructure, maritime, aviation, even sports, will come under stress from the same predatory takeover supporting states having technology, know-how, experience and funds as they will seek strong bargain from India. Private sectors will exercise tremendous pressure on sovereign structures for their survival and growth, and countries starved of foreign reserves or lack of domestic capital will be under pressure from these sectors to seek quick and cheap foreign fundings, all at cost to quick fix international obligations. It may be therefore possible that several countries may become debt trapped soon by the predatory states 10 years from now. Allow me to contextualize our analysis in case of top FDI investors in India. Singapore, Mauritius, Cayman Islands, UK, Germany, US, UAE and Netherlands, Japan and Cyprus. Together they invest about $59.6 billion in 2021. The top 10 sectors are computer software, construction services, trading, automobile, drugs, pharma, metallurgy, chemical, and telecom. Thus, the focus shall be how these 10 countries and India see international law and obligations in these areas. I will give you examples from only two countries, Netherlands and Germany. Since Netherlands is one of the most open liberal capitalist countries, private international law, that is government to business and business to business, occupies the center of focus. The obligations are generated through bilateral contracts instead of treaty framework. How Netherlands, a small advanced rich country, has been able to remain one of the top 5 FDIs for years without any formal dispute with India. Over more than 200 Dutch companies are there in India, and as I said, obligations are largely based on contracts than treaty law. Indian companies too are making major acquisitions in Netherlands. Indian companies, like in the United Kingdom, are good source of employment creation in Netherlands as well, as these are also more export intensive than the domestic firms. But, and that's catch, in 2019, due to COVID and increasingly protective foreign investment measures globally, the Dutch government recognized that the shift in the financial economic world order was one of the 11 dominant threats to the Dutch national security. In June 21, less than a year back, the government announced the introduction of a broader national security investment screening policy covering investments in vital infrastructure and sensitive technologies. I believe that establishment of the investment screening office in Netherlands to advise on jurisdictional and substantive questions which can also be consulted by market participants is a significant development which brings political concerns into business interest, whether we like or otherwise. These will have certain implications on bilateral relations, and government will try to find legal justification to protect and promote its interest. In March 2019, you might be knowing, the European Council adopted the EU Foreign Directive Investment Regulations. And this particular regulation provides for an enabling framework for member states to review FDI on grounds of security and public policy and to increase cooperation as a matter of priority between the member states. Thus, India's trade and investment relations with Netherlands will be subject to the EU policy in general, but Netherlands, being a liberal nation among others, will still have its nationalist approach to the investment and trade. In October 2020, the Dutch government enacted the Telecommunications Investment Screening Regime. The government significantly amended the draft act. Since telecom is an important area of collaboration, incoming and outgoing flow of investment will be subjected to this additional layer of scrutiny which was absent earlier. Notifications made under the telecommunications, energy, and national security regimes are subjected to far more strict reviews. Now, prior to 2019, this was completely a liberal open market. But these changes have taken place. Whether how these changes will affect the already existing contracts or bilateral economic trade and investment relations is a big inquiry. If you look at the latest Dutch Telecommunication Act, Electricity Act, and the Gas Act, these prescribed prohibitions on the privatization of electricity and gas transmission systems operators. Private investors cannot acquire such companies. And very importantly, the national security regime will apply with retrospective effect. Although we do not expect that it will be used, but the retroactive effect of the FDI screening rule will lead to uncertainty for business and investors. And in this sense, I'm particularly interested in learning how Mr. Sansi, who is with us today from Vodafone, because this case created a huge controversy on this very important aspect of retroactive effect. Thus, this analysis makes it clear that liberal international law will meet resistance for trade and investment facilitation as far as Netherlands is concerned. My remarks on German is quite similar. German policy on foreign investment has also become restrictive due to not only geoeconomic competition with China, but Germany's need and Germany's appeal to restore what it called technological sovereignty. The military goods, the critical infrastructure, and critical industries all are made subject to this particular scrutiny. These are also the areas where India is in need for funding and technology investment. It is interesting to note that acquisitions by Germany, purchases may also be reviewed by German ministry if the ultimate economic beneficiary is a foreign investor. In other words, outgoing investment from India to Germany in certain sectors now are more restricted. Now, what it says, now what are the warning signposts for India? The Western drive and the rise of economic nationalism will have serious implications for internationalization. In knowledge-intensive services where India enjoys edge, let's look at professional services, such as consulting and other soft services, which involve considerable face-to-face interaction. This requires the movement of people across border. But if you see the state practice of the developed world, Netherlands, Germany, USA, the visa requirements have significantly affected Indian service industry. Similarly, the international provision of many services, like for example, medical care, even design industry, also involves navigating registration requirements, which are now subjected to rapid change brought into domestic laws of these EU countries. Service-related business in industries that can be viewed as economic critical, for example, mining, oil and gas, or with substantial security implications, telecommunication, are going to find themselves subject to increased fluctuation concerning regulatory environments, challenging business managers' abilities to undertake even relatively, I'm telling, relatively short-term strategizing. It is therefore what I expect that there will be rising differences and disputes of commercial and investment nature. And in this sense, I was quite happy to see where Professor Makane was talking, because when I was looking at the ICSID rules, which is coming into force from 1st of July, ICSID rules, India is not a party to ICSID. It does provide certain relief. And I believe India would be looking at how these ICSID rules 2022 will play out into effect, and how the whole regime of international law and obligations will change in the years to come. Thank you.
Thank you so much, Professor Patel. I think the time is now ripe to get some views from our practitioners who are on the panel today as well. And in this regard, I would just like to say that, you know, the ISDS regime generally involves some kind of jostling between the government that wants to regulate as well as the investor who wants to seek investment protections. In this regard, if we look at, you know, certain instances or cases such as, you know, Occidental versus Ecuador, we've seen that the ISDS regime has been termed in many ways as being biased in favor of corporate interests. Ecuador had to face a $2.3 billion award, which at that time was the highest quantum of award ever rendered by the ICSID. And very significantly, this constituted 135% of Ecuador's budget for healthcare that year. And this has led to a certain kind of dubious overture towards bilateral investment treaties. So in this regard, my question would be addressed to Mr. Desai. Similarly, the white industries case had opened up India to the realities of multi-billion-dollar awards. And India's response to the white industries case was the Model Bilateral Investment Treaty of 2016, which was termed as more conservative than it ought to be by certain commentators. My question is that in the light of these kinds of conservative standards that may be enshrined in bilateral investment treaties, how much will this affect the perception of India as a viable destination of foreign direct investment?
Sure. Thanks a lot, everyone. Thanks, Scotch Group and India Law Forum for organizing this, and thanks, Anirudh, for getting this, panel to this level. But so my sense, we have heard a lot on the worldview, right? How things are moving depending upon external and internal factors. I think when it comes to India, we had a very different journey. And as always, India has always a unique experience to everything. I think if we just take a little step back in the history, we started our journey on BITs in the early 90s. And by the time of 2012, which is, I think you referred to the white industries case, we almost had more than 75 or 77 BITs by then, and maybe few others came a little more than that later. But we never had a single case except the Enron saga, which happened in the early 2000s, and that was even settled at that point in time. So almost for 20 years, while we had more than 75 BITs, we never had a single case against India till then. And if you see even white industries, it has come from a very unique situation, which is a commercial arbitration, which, the award was pending for enforcement for more than 7, 8, 10 years, and that was the reason why white industries BIT happened. And India responded in two ways, right? It was a small award comparatively, and luckily India didn't challenge. It paid off the amount, so that was, in my view, a good way to confirm that we are not here just to have the treaties and not adhere to it. On the other hand, it definitely in 2012 had huge impact on the FDI investment regime so far as India is concerned. I think the brand India at that time definitely took a beating. In fact, along with that, I think the retrospective aspects came along, and in no time, in less than 10 years, we have more than 20 BIT claims, right? So 20 years went by without a BIT claim, and then we had more than 20 cases in less than a decade. So I think we had a very different regime. But I would say the way I perceive and the way I saw things moving, I think 2012 to 2015, because so much was happening in terms of the investment protection and how India was reacting to things, the way Vodafone saga happened, where the new law was brought in just after the Supreme Court decision, striking off the notices issued against them under the taxation law. I think I would say, and we as a law firm look at the investment side as well, and we definitely saw that there was a huge impact between 2012 and 2015. Maybe the numbers or statistics will also show some kind of dip, or at least not the kind of growth expected at that point in time. But on the other hand, while Professor Patel, referred to 10 countries and the kind of investments coming from those 10 countries, but interestingly, in spite of more than 75 BITs, one country where we never had a BIT was US. And while it doesn't reflect in the FDI data. But directly, indirectly, in my view, US is still one of the most significant trade partner for India. A lot of investment coming through interim or interjecting jurisdictions originate from US or US related investments, and we never had any BIT there. Now, whether they use interjecting jurisdictions for tax purpose, for BIT purpose, or for multiple purposes, it's a different discussions altogether. But in spite of the fact that we had a very good relationships with them, we never had a BIT. So question always comes up in the context of India as to whether BITs do affect the FDI. Did white industry made a huge impact, and whether the new regime which came after 2015, which was much more conservative regime, and we didn't extend the existing BITs, as I think as Rohan mentioned earlier, several of them have been terminated or have not been extended from the earlier regime, and now only 4 or 5 are under consideration and or already signed, and more than 30 are under consideration. That shows that India is going very, very slow in signing those BITs. On the other hand, India is still the top 10 destinations of BITs. I'm just giving you two different views just to bring the context that one would never know this impact. Now, can I say that if we would have a very liberal BITs, we would have 2 times, 5 times the investments? I don't know, because unless we have it, nobody can vouch it, right? Whether we are getting less because of non having the BITs, our experience from a US perspective, I don't think it has a direct correlation so strong. But yes, if we don't have the focus and the regime, as even earlier we heard about the promotion and investment and protection goes hand in hand. I think India will never get the kind of attention which it ought to. Maybe it will still be top 10 of the FDI investment, but it is losing out on the potential rather than saying that, look, our fundamentals are so strong, and having that arrogance or otherwise. Maybe we'll still continue to have FDI because maybe there is less choice beyond this top 10 destinations, and we have very strong fundamentals in terms of our geography, our diversity, the kind of mix of young youth, and the economy which is self-consuming in that sense. We don't need to look outside for consumption. I think we'll continue to have the investment, but to say that it doesn't have an effect, I don't think that is correct. I don't think we will ever get the right data, but we'll definitely not get the potential, the growth potential, if we don't have both the promotion and protection in place so far as the world order is concerned. Now, obviously, we can discuss the current set of new BITs post 2016. More importantly, interestingly, India, Brazil, maybe a little later. But my initial thoughts are that while history says that it may not be directly proportionate, but in my view, we are not, getting our potential growth because of not having the right promotion and protection regime from an investment perspective. So that's broadly how I see the effect of white industries. In fact, sorry to I just remembered in 2011, even before white industries came up, I was in the Harvard University in Boston talking about BITs, and people said, why an Indian lawyer or Indian firm is even talking about BITs, because we had no experience other than Enron. But we saw that coming. We thought that this is something that we are not giving enough focus. And then white industry came, and then everyone was talking about BITs. Until 2015, definitely it was not a great time. Yeah. Thank you.
Thank you, Mr. Desai. So we already have a very interesting cleavage of opinion that has developed in this panel, while Professor Makane is very blunt and he is of the opinion that there is absolutely no relationship between foreign direct investment and greater FDI. Mr. Desai seems to believe that by not signing FDIs, you are still foregoing on the potential of foreign direct investment. And indeed, India's image did take an impact, was impacted actually after the White Industries case. My question would now be addressed to Ms. Briercliffe. In your experience, do you think investors look at destinations with greater protections differently? And what alternatives do they have should they want to invest in jurisdictions that do not offer such protections? What has your experience been?
Thanks very much, Anirudh. And I echo the thanks of the other speakers for having me on this panel today. I think I'm going to end up probably somewhere towards the position of Mr. Desai, because in my experience, the investors that I advise do tend to take the availability of investment treaties into account when making international investments. And provided that a treaty provides adequate protections, including, and I'm sort of emphasising this here in light of India's recent investment treaty practice, the availability of investor-state arbitration, then those treaties are viewed as an important mitigant of political risk, and therefore a factor that is taken into account in whether or not they conclude an investment. Now, whether or not the investments would have been made in the absence of an investment treaty is another question. And, you know, we've heard Professor Mbengue on his views on that. And I tend to agree that broadly a favourable investment climate is going to be the thing which attracts, is the most important for an investor when making an investment. But where investors perceive there to be risk, and I think that there is, you know, from some quarters, a perception that India is a risky investment jurisdiction, largely due, in my view, to the people's perception of the Indian court system. And then in those circumstances, investment treaties can help investors to get comfortable with investing in that environment. So as Mr. Desai says, perhaps India is getting great investment flows, but you know, if there were available investment treaties with sufficient protections, then maybe there would be greater investment flows. Now, of course, there are alternatives for investors when considering to make investments, how to mitigate political risk. For example, they can enter into investment contracts that contain favourable dispute resolution provisions or other clauses which manage host state risk, or indeed can undertake political risk insurance. But none of those alternatives to mitigate investment risk is of the same scope and benefit as an investment treaty, which contains the investment protections that investors generally look for. So I think that, you know, my view is that you know, the benefit of investment treaties is likely to depend on jurisdiction. Whether or not an investor cares will depend on that, and then also the sector they're investing in, whether the investment is going to be made in a project where they have a direct relationship with the host state. And in those circumstances, probably an investor is likely to consider, well, what recourse would they, what luck would they have in getting recourse against that state if there were to be a problem before the host state's national courts, or if they have investment treaties, or if they have, international commercial arbitration in their contracts, will they be able to enforce that award? But where they have any doubts about that, and in my view and in my experience, some investors do have doubts about that in the context of investment in India, then an investment treaty, the possibility of investment treaty arbitration becomes very important.
It's very interesting to know that investors do actually look at these investment protections before they venture into making that investment in a territory. And it's very refreshing to know that you have also seen investors do that in your practice. But if we look at the current BITs, we will also notice that the architecture of these BITs is also gradually changing. And to give you one example, the Indian Model Bilateral Investment Treaty from 2016 did away with the FET standard completely, and also changed the definition of expropriation to eliminate judgments and arbitral awards. So whether an investor would then, maybe change its perception about whether it wants to go ahead with an investment or not, will be interesting to see in light of these changing standards in bilateral investment treaties. But specifically with respect to investment contracts, an investor has many forums before which he may have recourse. An investor may have recourse before an arbitral tribunal, and he may have recourse before the courts of the national jurisdiction, or may also invoke investor-state arbitration. Mr. Sansi, in your opinion, in light of broadly worded treaty protections, would you recommend arbitration under a treaty as the best available alternative? And do you believe that such broader and open-ended treaty provisions makes the recourse to treaty arbitration more amenable to an arbitrator, to an investor? Mr. Sansi, I believe you're muted.
Hello, am I audible now?
Yes.
Okay, let me start by thanking you all for having me around on this forum, and it's really so enlightening to hear all of you and your views on this. And before I get into the specifics of answering to the point that you raised to me, I would just want to elaborate and put forth my view on the issue of, or on the point of, a must-have or good to have investment treaty. And I'm going to sail in between the two positions that have been taken thus far, between what Mr. Makane said and what Mr. Desai just now said. My view is that investor protection treaties is in the form of, say, bilateral treaties or whatever. I mean, these are not must-haves, but are good to have, right? And I can explain this with an example. India went ahead and terminated so many of its BITs mid 2000 in the last decade, right? And that was also the time when India possibly has seen the best FDI inflow, right? So it goes on to say that while the country may not have a robust BIT regime and had rather gone ahead and annulled many of those, but still it was able to attract a lot of foreign investment into the country, and which is just pointing to the fact that it is bilateral investment treaties are not must-have. But then, as Naomi just now mentioned, as she deals with a lot of investors and who potential investors, and they show their interest and curiosity about what is the investment protection regime that the country offers. So from that perspective, I would say it will always be good to have a sound and a robust bilateral investment treaty regime in the country, which can provide good investor protection. This is what my view is, and therefore I'm going to say, as I said, I'm going to sail between the two positions which have been taken till now. Now, coming to your question on now, what are the what your question was on, is investor protection treaty the best alternate, or there are other alternates? I think that's what your query is.
Yes. So my question is that when we talk about investment contracts, investor out of the same contract may have different forums to ventilate its concerns. And given the broad-based nature of treaty protection, do you think as an investor, the investor would prefer to go before a treaty forum only because of the broad-based nature of the protections that are provided in it? And therefore, and in other words, is treaty arbitration the best available alternative for an investor from an investor's standpoint?
Well, I don't think there will be a one fit suit all type of an answer to this, and it will depend on a case to case and an investment to investment and the type of dispute that is there. But I would rather say that this is not the only best available dispute resolution alternate. There are other international commercial arbitration options which are quite effective and are quite and are quite adoptable, if I may say so, for investors to have in their investment contracts. Yeah.
Therefore, Mr. Sansi, you believe that there are other viable alternatives as well.
Oh yes,
and
absolutely.
and it's extremely interesting that you voice this view, because as we speak, there has again been a very large movement in terms of changing the way the dispute settlement mechanisms under investment arbitration are also articulated within treaties. And one solution can be found in, for example, the CTAC, where the proposal has been to establish a multilateral investment court. And similarly, another alternative is possibly recourse before the domestic forums, which is a revisitation of the Calvo doctrine, so to speak. The Indian model bilateral investment treaty provides that before an investor wants recourse to treaty arbitration, it has to exhaust local remedies for a period of 5 years. Now, some commentators have viewed this provision as being very onerous. Mr. Desai, do you believe this to be an onerous condition? And in your opinion, do you think the domestic forums in India and Indian courts are fit to adjudicate and find solutions to an investor's problems?
Yeah, I think it's a very interesting provision, and the pendulum has shifted, right? I think pre 2015, the way the investment treaties were negotiated, it was all about India being an capital importing country, and then we got our own confidence on our own internal macro level strength rather than the micro level issues. And with the white industries experience and thereafter the Vodafone experience, which was ongoing at that point in time, obviously India took a very different stand. Now, going through the local available dispute resolution mechanism, came about along with many other different aspects which came in the model BIT. But let's look at this in a little context. I think it's not only India, but world is moving away from the way the regime for investment treaty or bilateral investment treaty protection or the dispute resolution mechanisms were, pre 2010, pre 2015, and what it is today. Many other countries, not only India, have taken even more stringent and conservative approach than what India has taken. So I think rather than being very critical about India, I would look at this as a trend worldwide. And then obviously we have taken what we thought is relevant, and we decided, okay, why don't you at least exhaust your local remedies rather than jump onto the treaty? Look at it from that context. Now, from a macro level perspective, right? When it comes to micro level, I agree with you. It's not an easy task to understand that when we have 30 million cases pending in country, to say that a foreign investor would look for local remedies. In fact, white industries is a classic example of a BIT because of pendency in local remedies, right? So in a way it's a contradiction. While we faced an investment treaty protection because of non-availability of local remedies, now we are imposing local remedies as part of precondition to BIT, claim. So I think somewhere we will have to put our internal processes in place. We have to put, as I think Manish also referred, that there are other ways to deal with this situation. People don't have to jump directly on the BIT claims. If we are able to give those protections either through international commercial arbitration or through court regime or through specialized court regimes, then this can be better handled. And I just take, maybe 30-40 seconds on this from that perspective. See, just take 3 examples: how Vodafone has been handled, how Kane Energy arbitration has been handled, or even Devasantrik's case is handled, right? Devasantrik's case, we had an international commercial award that is running in parallel. Now we have a BIT issue that has been handled differently, including bringing in several different amendments and taking local court defenses or methods or strategies to avoid those situations. In Kane Energy, we lost, but we had to ultimately settle because of the way enforcement happened. And Vodafone started, if I may use the word, vindictive in a way of the Supreme Court order. And then we are at a stage where, to justify a retrospective amendment is becoming a problem, right? So I think our experiences on different BITs is very different. And this is the culmination of the new model BIT, where we say that, look, please first adopt the local remedies. I don't see per se that is wrong. I think where we go wrong is on the execution of it. If we are able to actually develop a regime to address those concerns effectively, efficiently, and in a timely manner, then why not? I think the criticism is, in my view, is not about the aspect of going through local remedies. The criticism is that that precondition makes the process futile, right? And if we are able to give some platform to address those concerns, I think it's a great balance between rushing into a BIT claim versus having a protection. While, the India-Brazil treaty, talks about no investment protection, it's only state to state in that sense. So I think rather than going that far, this creates some kind of a balance in my view. But again, this is my personal view, and we'll see how it works out.
Absolutely, Mr. Desai. And if we were to just allude to, for example, the very celebrated BG case, the BIT with Argentina in that case had a provision that provided for, exhaustion of local remedies for a period of 18 months. And the contrary argument to that was that how can, you reach a solution within 18 months only. So India's position has been, if not 18 months, let's make it 5 years, because perhaps in 5 years, because it's more than 18 months, there will be more of a likelihood for the investor to have a solution to his problems. But as you said, that the provision for exhaustion of local remedies should not be seen in isolation, and it needs to be seen in light of other developments that are taking place across the world. And perhaps the most obvious country that comes to my mind is South Africa, which in 2015 also terminated all of its bilateral investment treaties and provided for the investor to actually approach the local South African courts. And if that did not yield to a solution, then the provision was to enter into conciliation with the government of South Africa. And therefore, your views are actually very well taken that the provision for exhaustion of local remedies should not really be viewed in isolation. Mr. Patel, there has been now a growing trend away from multilateral dispute settlement, where countries like India are entering into free trade agreements that provide for their own unique ways of dispute settlement, which are not like the traditional ISDS model. Do you find any merit in this approach?
Thank you, Anirudh. Indeed, one witnesses an increasing trend for specific free trade agreements in India. Does this mean that a deep dislike for free trade amounting to distrust of FTAs enabling foreign producers unrestricted access to domestic markets is fading away? Or, for example, is India saying that FTAs are non-inimical to the national interests, such as economic sustenance of local producers and achieving self-sufficiency? What one can think is that given the conspicuous lack of support for free trade in India, Indian trade policy is expected to become narrow and restricted in scope. The trade engagement, in my view, is likely to be selective, focusing on partners with whom more trade would be furthering the specific national interest, like expanding export-oriented domestic production without facilitating imports. India's withdrawal from domestically much criticized RCEP reflects the profound influence of inward-looking mindsets on India's current and near-term trade policy, making India's trade outlook more circumspect and selectively engaging. For example, India would be interested in pursuing more beneficial, quote unquote, FTAs like the one with the Bay of Bengal, the BIMSTEC country, Bangladesh, India, Myanmar, Sri Lanka. As the largest economy in this grouping of countries, that is BIMSTEC, India's economy and geopolitical heft would help India in fashioning an FTA tailored to its advantage. And as we all know, import threats from most BIMSTEC members, except Thailand, are limited. Indian exports to these countries would increase further from tariff cuts in the FTA, as would Indian FDI through liberal inward investment rules, enlarging the prospects of Indian business, creating value chains around this entire BIMSTEC. So having an FTA with countries around the Bay of Bengal also will help India geopolitically, principally in terms of countering, let's say, Chinese influence in these regions. So what I do expect is that India will be pursuing beneficial FTAs. And therefore, when I was listening what the Prime Minister Johnson was saying last week, that the FTA with Britain would have been concluded by sometime, let's say, in October, November. So on one hand, though Britain itself is going to have much more inward-looking, because it's going to have FTA with the European Union as well. So how these dynamics will work out, that will be quite interesting to see. But at least in the near future, I do see that India will prefer more beneficial FTAs like what we with BIMSTEC than what one would expect, bigger, like big multilateral RCEP kind of treaty framework.
Right, Professor Patel. So far, our debate in this panel has concentrated on procedural reform, but a very equally important movement in the way of ISDS reform has been towards certain substantive aspects of BITs. And Ms. Briercliffe, there has been a move away from the traditional bilateral investment treaties in some of the recent BITs that are being signed. And the move has been towards a new world that imposes investor obligations. Now, this is very significant because ISDS is traditionally viewed as a skewed way of dispute settlement, which only gives the right to an investor to invoke arbitration, but does not give the state a corresponding right. Therefore, the view to impose these investor obligations has actually been welcomed. In your opinion, do you believe that imposing investor obligations is a good way of regaining the trust of countries that do not really want ISDS? And do you think it is better than completely abjuring ISDS altogether?
So this is a very interesting question. I think broadly, in my view, if a state is of the view that they don't believe that investor-state dispute, investment treaties encourage investment flows, and they don't want ISDS, the best position they can take is just not to sign these treaties. But I think that that, from as I've sort of explained, I think that position would be short-sighted, given that I do think that there is some benefit to these treaties in encouraging certain types of investors. As to whether including investor obligations is a fix for rebalancing treaties, I'm not convinced. Not because I think there's anything wrong in having investor obligations, and I do think that if they were to work, it would create some sort of balance. But the problem is, at the moment, the treaties that I've examined, I think the investor obligations are somewhat aspirational as opposed to being effective. On the basis that these are treaties that are concluded between two states, on what basis does the obligation come into effect? At what stage does it come into effect? We haven't yet seen any cases in which these obligations have been tested, but I see some real jurisdictional issues in them working as things stand. And I think states are probably, maybe there's a sort of a public policy basis for including them. It's to emphasize to investors that they need to accord with certain standards, but better to make those standards applicable to the investor through a direct contract or under domestic law. A way to balance the treaty is to focus on the substantive content of the obligations that are imposed on states. And there, I think, we're seeing a lot of movement in that direction too. We've talked a little bit about India's model BIT of 2016 and how the standards have been circumscribed there. And I think states are wise to consider how their standards in their investment treaties are circumscribed to best reflect the intentions that they had when entering into the treaties. I think that we're seeing a movement in investment treaty jurisprudence towards sort of deeper understanding of the way that these treaties are intended to operate, and a more consistent application of the law generally. And obviously every treaty is different, but we can see that there are similarities between them, and there is broadly a much more consistent approach to the interpretation of treaties than there ever has been in the past. Nevertheless, we've seen that there is a risk when you're leaving the interpretation of these treaties up to an ad hoc tribunal, and so a state focusing on the precise language of the obligations that they enter into is very important. I should say, though, there's a difference between negotiating and agreeing carefully circumscribed investment treaty standards and agreeing a treaty that has no real content from an investor perspective. And I think that, at least from my standpoint in advising investors, any treaty that's concluded that doesn't give an investor a right to invoke the state's obligations directly through international arbitration is in effect redundant. It's a nice thing to have on paper, but it's not something which is going to encourage or an investor or give them any comfort as to the treatment with which the treatment that their investment's going to receive.
Absolutely, and while you may be advising your investors and clients to maybe not take recourse to international arbitration in cases of treaties that do not really offer any meaningful alternative for dispute resolution internationally, the fact also remains that even in a very utopic world, even if we were to have the best possible bilateral investment treaty, there always exists a possibility, especially in non-exit countries, that a country may yet choose to not honor its commitments in arbitration. And therefore, an investor, despite having the best possible treaty, may still face obstacles during the phase of enforcement. And that is something Mr. Desai highlighted during the course of this discussion when he was talking about the Kane arbitration. And the Kane arbitration is actually very interesting because in the face of an award that was favorable to the investor, India still chose not to honor the award. And the investor did face a lot of trouble in recognizing these rights. So much so that they had to go to courts all across the world, including the US, including France. And in the French courts, there was an order of attachment of the properties of the government of India for $23 million. Therefore, the point is that even after successfully emerging as a victor in investment arbitration, an investor may still have problems. Mr. Sansi, according to you, how important is it to have a continuous investment policy in preserving investor confidence? And I ask this question because the normal refrain that the government takes in not honoring these awards is that these obligations were not really assumed by their government. They were actually assumed by a prior government, and they are being saddled by these new obligations that were assumed by a prior government. And that is normally the justification for not honoring these commitments. And I would like to know, in your opinion, how important would a continuity be to avoid such an eventuality?
I mean, this is of utmost importance, Anirudh, to have continuity of of laws, continuity of tax regime, continuity of regulatory regime. You know what? From an investor's perspective, it really doesn't matter whether a particular regime or a type of a regime existed when there was a different dispensation, and now at a different point in time there is a different dispensation. I mean, that's very unfortunate for any state to say that a particular set of laws were existing in the prior dispensation, and now since the dispensation has changed, things ought to change to the disadvantage of an investor who's already invested. So continuity of regulatory regime, continuity of tax regime is of utmost importance, I would say, Anirudh. And I mean, even if to ensure that continuity, there are some short-term losses for a state, but in the longer term, to attract more investment, better quality of investment, and investment both in terms of funds as well as in form of IPR stroke technology, it is important that there is an absolute continuity of and predictability, if I may call it that way, of the regime in terms of laws and regulatory environment for the country. Yeah, over to you, Anirudh.
Thank you, Mr. Sansi. It appears
Hello?
we
Anirudh,
lost,
over to you. Can you hear me?
I believe we lost you towards the end. And if you could just recap maybe something you had just said, it will be really good for all of us.
So I will summarize. Sorry for this bad connect. Actually, I'm not in a place where the Wi-Fi is extremely good. But I'll just repeat and summarize. You know what? I mean, this is a question which has a very simple answer, right? From an investor's confidence perspective and from the perspective of protection of investors' interest in a state, in a jurisdiction, continuity and predictability and stability of laws is extremely important, right? It just doesn't matter for an investor or a set of investors that there was a separate set of laws or separate approach towards a matter when there was a different dispensation in power in a particular state, and now there is a different dispensation. That continuity has to be there. Yes, laws will continue to evolve, laws will continue to change, but then there has to be predictability of the changes, and there cannot be an arbitrariness, if I may call it that way, in terms of the changes that may be brought in laws. So continuity is of utmost importance, if that was your question.
While continuity is extremely important, we have states like India and Brazil and South Africa that I mentioned specifically that also want to provide for an equilibrium between the continuity of laws and their own ability to regulate what is happening in their country. And therefore, because of that, we have seen a move away from traditional dispute settlement mechanisms, specifically with India and Brazil. Now, India and Brazil signed a bilateral investment treaty in 2020 that provided for the investment facilitation way of dispute resolution. In the beginning of the discussion, I had quoted a passage from one of the investment negotiators from Brazil, who believed that there was no real merit in traditional dispute settlement because it did not really concentrate on the cooperative aspects of it. The India-Brazil model BIT, as I said, offers a very novel way of resolving disputes, and it provides for joint committees that may be formed between these two governments, who may then collaboratively and in a collegiate manner come to dispute resolution, to resolve the dispute. Now, in the event that dispute is not really resolved, then the only recourse is state-to-state arbitration. And in this sense, the investor is completely eliminated from the process. Mr. Desai, do you believe there is any inherent advantage of eliminating an investor from the process of dispute settlement, particularly because the whole concept of the modern ISDS approach was to do away with diplomatic protection?
Sure. No, I think it's like, again, we are talking about investment protection and we are eliminating investor from the whole game, right? Obviously, innovation in every aspect of life, whether it is business or political, is going to be, the order of the day. And I think, if I may call it, this is, while we talk about many technology disruptions, I think this is the biggest disruption in the BIT world, which is, going to have a lot of debates going forward. But I think what countries forget, right, that this kind of mechanisms are not only when you are talking about investor going against yourself. It can be the other way around as well. Like many Indian companies are going abroad, and there are instances in the past where Indian investors have used BITs to protect their investments outside India, right? So I think somewhere you can't only look at this only from an inflow perspective. You also have to look at it from an outflow perspective, and how are you going to protect your own corporates when they go and invest outside. So in my view, this cannot be just one way of looking at it. You will have to see it from country to country, and you will have to see from how you balance it when you are looking for investment both ways, right? That is one aspect of it. Second, it is one aspect that, look, you are eliminating investor from the whole game, and it is state to state arbitration. But what if investor doesn't have a good rapport with their home state governments? How will that work out? What if investor doesn't have the right channel of communication with the home state, and there may be several other reasons why the home state would act in a particular manner in a situation, rather than worry about a particular investment from a particular investor in the other state where they have to run a state to state arbitration. I think it throws up more complications than what it is needed for the protection or the promotion and protection of investment between two countries. And I would look at it little more skeptical in this sense, because this definitely does not give the sense of confidence an investor would want while entering into a new jurisdiction, because it brings in a completely different aspect of state to state discourse. I can understand there can be several preconditions to invoking an arbitration, whether it is exhaustion of local remedies, whether it is committees between two states. We can look at how this can be effective and efficient before the investor has a particular recourse, either in a commercial arbitration or otherwise in an investment treaty arbitration. We can look at different models, but to eliminate something which provides some degree of protection to the risk to the business. See, at the end of the day, any business decision can be made based on analysis on risk. But how do you analyze? How do you take a decision on uncertainty where it is not under your control? I think businesses, hate uncertainty. They don't hate risks. So long as you tell us, okay, this is the risk, they can take a decision on that risk. But if you tell them there is a complete uncertainty how state to state arbitration would work, it becomes very difficult to take a decision on those aspects. So I would view this this development, little more, I would say, on a skeptic kind of a view, rather than, of course, I'm not totally negative on it, but I don't think this is something which can sustain in a long run. That's how I look at it.
Therefore, at the end of the day, the debate essentially boils down to whether India, now as it is embarking on its journey as a capital exporting state, whether Indian investors will also be likely to avail the same protections that their government may deny the other foreign investor. And therefore, there has to be a balance, and the government will have to take a call as to whether they will benefit by completely eliminating an investor from the process against the risk of incurring multi-billion-dollar awards, or whether they ought to give the same opportunity to their own investors in the current system to go and resolve their disputes under a mechanism that does not seem to, on the face of it, provide any impediment. And your point, to a large extent, has been that this politicizes the process as well, because if an investor does not enjoy confidence in the government, then the investor does not get a forum to voice his concerns. And at the end of the day, it is the government only that suffers, because that investment is never protected. Now, India has not been a party to the ICSID convention. And a related issue that comes up in the case of protecting foreign investors is the enforcement of investment arbitral awards in India under the New York Convention. Ms. Briercliffe, there has been a cleavage of opinion between two different schools of thought in India, one which believes that investment awards may be enforced, and one that believes that they cannot be enforced. Are there any arguments for an investor from a non-ICSID state to enforce an arbitral award outside the ICSID convention? Are there any inherent advantages to this approach? And what are the benefits for a state to sign on to the ICSID convention?
Thanks, Anirudh. Yes, so my understanding, and I'm obviously not an Indian lawyer, but my understanding is the issue that arises in relation to the enforcement of investment treaty awards in India stems from India's reservation to the New York Convention, that the convention only applies to differences arising out of legal relationships that are considered commercial under national law. And there have been different approaches by the Delhi High Court and the Kolkata High Court on that. And now, as to whether or not there are arguments for construing the position in favour of the enforcement of investment treaty arbitration awards under Indian law, I can't answer. But from a public policy perspective and thinking about third states, as you mentioned, yes, there is an argument in favour of that construction, or indeed, India clarifying its position to make investment treaty awards enforceable, because there's very little benefit to having, well, from an investor perspective, the possibility of recourse against a state if an award can't ultimately be enforced against that state. And now it might be possible to enforce an award in a third state where a state has where the host state has assets, but in most instances, the majority of a state's assets will be in its own jurisdiction. And so an investor will want to be assured that they are able to enforce an award domestically. Now, of course, everyone hopes that a state will comply with an award voluntarily, but it doesn't always happen. And I think from India's perspective, or any other state in India's position, the benefit of having enforcement under the New York Convention is, of course, that there is some degree of a national court review of awards before they're enforced under the New York Convention. There are limited bases on which a national court can find that an award is not enforceable. For example, if it contravenes public policy, or if there is an issue with there was an issue with the tribunal's jurisdiction. And they're very limited grounds, but they do exist. And I think, so they're by allowing awards to be enforceable, investment treaty awards to be enforceable, you create investor confidence. And then on the other hand, the New York Convention offers that sort of domestic oversight to some degree. The ICSID Convention, of course, doesn't offer that, or shouldn't offer that technically, since under the ICSID Convention, ICSID awards are to be enforced in ICSID Convention states as if they were a domestic judgment of that state. So there aren't those kind of grounds for review that exist under the New York Convention. However, the ICSID Convention is really seen as the hallmark of for investors of an instrument which gives them confidence in an investment treaty system. And certainly in almost every instance where I've advised an investor, if ICSID arbitration is available and the relevant state is a party to that convention, the investor will pursue ICSID arbitration for that very reason. And it's not that there is no possible recourse against an award at all within the ICSID system. That's not right. There is. It's possible to seek annulment of an ICSID award within the ICSID system for very limited grounds. So if there's a real problem with the award, it can be addressed, but it's addressed in that supranational structure that ICSID is, rather than before national courts. So, overall, ICSID, it offers investors sort of greater protection, as it were, but perhaps the New York Convention offers some balance that the states hope for.
I think with those remarks, we've almost also reached time. But before we part ways, I would want to yield the floor one last time to Professor Patel. As a parting remark, how do you think that the civil justice system in India can improve and ensure confidence for foreign investors?
Thank you very much, Anirudh. So unlike my remarks on the previous two questions where I speak of figures and facts and names of the countries, here I'm going to be a little more academic. So if you see the last 10 years of jurisprudence and also the legislative framework of India, it demonstrates clearly the critical role of justice for fostering a healthy business environment, enhancing growth, improving access to public services, curbing corruption, and also restraining the abuse of power. If you look at our courts, prosecutors, complaint mechanisms, anti-corruption agencies, ministries of law and justice at union as well as state level, which are foundation for the social contract between people and the Indian state, they have been addressing breaches of law, providing redress for violation of rights, whether it is commercial rights. They have been facilitating resolution of trade, commerce, and investment disputes. In fact, they have been effectively overseeing the state institutions and enforcing the state's role as regulator, which is not being spoken loudly about. Because of this, the culture of accountability has increased, trust in the government has been growing, resulting into expanding of capital markets. It would not have been possible if you look at simply the expansion of capital markets. It is really phenomenal. The investment by foreign houses with confidence that their property rights are protected. More interpretations, more clarifications are provided. Although, of course, it has caused certain political damage to the government in power, but that has enabled a strong confidence culture. Let me give you tangible empirical evidence. Government has created mechanisms which are responding to citizen claims and grievances. I'm talking in the area of, let's say, healthcare. There are certainly challenges, but the results are there for us to see. Again, thanks to the three organs of the state, they're facilitating the litigation of tax cases, thereby helping tackle tax evasion and corruption. The results are there for us to see. The government focus on community-based mechanisms to resolve community conflicts are yet another sign that justice institutions are working. Let's look at extracting industry. We talk about the white industry case among others as well. The compliances are taken by the actors. The arbitration councils and institutions are being promoted. The results of these institutions will be seen in 10 years' time. Look at the Financial Intelligence Unit and Enforcement Directorate. Money laundering being fought before. The government focus on administrative laws and delivery of services is yet another strong achievement that our civil justice system and of course criminal justice system as well are responding, preventing and able to create faith, fear and respect. I'm not saying that there are challenges at macro level, but these are the long-term measures which are increasing foreign investors' confidence. I can tell you from an example of Law Commission, and I can say that some of the reforms which we proposed as a member of as the Law Commission, these reports were adopted and they are worked by the Supreme Court as well as the government. In fact, I was personally involved to a great extent, and we removed as many as 1,600 acts, out of nearly 7,000 acts. Now, if you see the impact of those removal of these archaic laws, among others, which would have a direct impact on what we are talking today, trade and investment, will be felt in years to come. So what I'm saying is that the legislative reforms and proactive civil justice system are going hand in hand. And despite simmering tension between executive and judiciary at times, and of course, the law firms and the lawyers, they would have different opinion. I think we have been able to demonstrate and ensure greater confidence. And as various world institutions, they are saying that India does remain a bright spot. And India is keeping in mind the twin goal of increasing on one hand investors' confidence and at the same time protecting and promoting national interest, including security. And I think this is the game of balance which India will keep doing. But overall, if you see, there is a huge reforms, subtle reforms as well. And 5 years down the road, you definitely see much more investor confidence both at G2G level as well as B2B level.
Thank you very much, Professor Patel. I think we have two audience questions here, which we would also want to ask, and I believe we have some time for that. The first question is directed to Ms. Briercliffe. And the question is that one may think that India's experience as a respondent state in investment arbitration has pushed the state into a rather protectionist cocoon. What are the possibilities of India setting up specialist courts to solve international investment disputes?
I mean, it's a question for the Indian government related to its own sort of capacity and interest. But that's certainly an option which is being looked at very closely by other governments around the world. In particular, states in the European Union are very clearly pushing for the establishment of an investment court as being a solution to or an advance on investor-state dispute resolution before ad hoc tribunals. And of course, at the moment, there are very detailed discussions ongoing before UNCITRAL Working Group 3, in which I believe India is participating, discussing whether or not there should be universal agreement on the establishment of some sort of permanent institution to address investment treaty arbitration. Now, we probably don't have time to discuss all of the pros and cons of that option. If it were to lend greater confidence from both the investor and state side in the investment treaty system, then I can see arguments for it. But from a practical perspective, whether it really moves the dial and makes a difference, I'm not convinced. I think that there are some serious cons from a kind of efficiency and cost perspective. But I don't really think that the reason this alternative is being proposed is actually to improve the system from a kind of procedural perspective. I think it's more about restoring confidence in the structure overall.
Thank you. And our second question is addressed to Mr. Desai. And the question is, India has terminated 68 bilateral investment treaties recently and is negotiating new ones based on the 2015 model BIT. How do you think that is impacting investment in India?
Yeah, I think we covered that a little bit during our discussion in some form. But as I said, this is not an India phenomena, right? I think as Naomi also talked about, Europe moving out of an arbitration regime to a court, dispute resolution mechanism. And there also newer provisions are coming in terms of what kind of state-to-state protections will be granted in those agreements, including, I think you and others also refer to the South African, model and then the Brazilian model. So I think this question is, very interesting because one would never know what the world would be without this kind of a stringent BIT, right? Because we'll never experience that world. We'll only deal with the situation which we are in today. But my short answer is definitely it is one of the criterias for an investor to decide on the jurisdiction they want to go into. Maybe there are other criterias where India will trump other jurisdiction and therefore investor will still come. But if you have a apple-to-apple comparison and without a proper investment treaty regime or promotion and protection regime, then definitely India will lose out on such a stand being taken so far as the promotion and protection of any investment is concerned.
Thank you very much. And I believe that brings us to the end of today's discussion, which I found to be extremely fruitful, insightful, and thought-provocative, especially on a weekend. I would like to thank all of our panelists today who took out time from their very, very busy schedules and addressed certain very important aspects that have been plaguing the ISDS system. There were some agreements, there were some disagreements, but I'm glad that there were more agreements than disagreements. And I think that is the biggest takeaway from today's discussion. I would like to thank everyone for their candor. And I hope you found this equally informative, just like I did. I hope your Saturday was as good as mine was. And thank you so much for being here. Thank you so much for having such an analytical discussion on certain very, very burning issues.
Sure.
Thank you.
Thanks a lot. Thank you,
Very
everyone.
much.
Thank you very much. Namaskar.